The DOJ, AG Bondi, and 25 states are now joining the fight against statewide concealed carry ban laws, which this is now in front of the Supreme Court. So let's break down what is now happening. Now, really quick before we jump into this video, if you guys want to support the channel for free, please consider subscribing to the channel. That of course helps the channel to grow. Also double check to make sure YouTube has not unsubscribed you because they do that quite often. And then just drop a positive comment down below because that helps to tell the algorithm that you appreciate this type of two-way content and it should share it to more people. Now, as I mentioned in the intro, in this video, I have some important updates for you and for everyone really who lives in states like New York, California, Hawaii, New Jersey, and others who are currently facing attempts to ban concealed carry within those states. You may recall that recently the Ninth Circuit Court of Appeals issued a decision on multiple concealed carry laws, which were passed in direct response to what the Supreme Court said in their Bruin decision. One of those was the California SB2 case, and then the other one was out of Hawaii, and it deals with the Hawaii state ban on concealed carry. The case which is currently seeking Supreme Court intervention is the Hawaii Wolford versus Lopez case. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states in their catch-all public carry bans are permissible under the Second Amendment. Well, recently we talked about that there was a little bit of a surprise because the DOJ, AG Bondi, and the Trump administration stepped up in support of this challenge in the Supreme Court. They recently filed an amicus brief to the Supreme Court arguing that it was finally time for the Supreme Court to review these concealed carry ban issues that were passed directly after Bruin, and it was finally time for the Supreme Court to strike down lower court defiance. This effort has now also been joined by 25 pro-2A states who are also calling for the Supreme Court to stop the active defiance of the lower courts and the active defiance of some of these liberal states. These 25 states have joined with the Trump administration to call for the Supreme Court to finally take action. And the 25 states that have called for this action and for the Supreme Court to finally review this case are Montana, Idaho, Alabama, Alaska, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, West Virginia, and Wyoming. And then also the legislator within Arizona joined in this brief. Now, this case is a challenge to Hawaii's new laws on concealed carry, which they passed in direct response to Bruin. This law, like others, tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property only if the owner of that property provides express permission to do so. This new law sought to operate in a way that Hawaii could still ban concealed carry despite what the Supreme Court said. Now, prior to Bruin, you had a lot of laws in states like Hawaii that operated as may issue states, but in practice, they really never actually operated that way. They would simply just never issue permits. In fact, in 2018, the Ninth Circuit noted that Hawaii had issued only 4 concealed carry licenses to private citizens in the past 18 years, and that in one county, not a single concealed carry license had ever been issued. However, in Bruin, the Supreme Court held that the Second Amendment guarantees a general right to public carry arms for self-defense and that may issue licensing regimes for concealed carry handguns like Hawaii's pre-Bruin regime did in fact violate that right. Hawaii, in response, passed Act 52, a statute that overhauled the state's carry laws. Like New York, they tried to put in place a very restricted license, a very restricted permit process, and also restrict where you can carry, and ultimately ended up being worse than the ones that existed prior. Because of this, plaintiffs, along with 2A orgs, sued the state of Hawaii to strike down this law that was put in place. Now, on review, a district court issued a temporary restraining order, or a TRO, which was later converted to a preliminary injunction. In that decision, the district court blocked the private property rule as likely a violation of the Second Amendment, and they said that it was inconsistent with Bruin. This case then made its way to the Ninth Circuit Court of Appeals along with the California carry ban, and on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction issued by the district court. The Ninth Circuit relied on older restrictions on hunting on private property to support this statewide concealed carry ban. Now, after that, the plaintiffs then asked for the Ninth Circuit en banc panel to review this case, but that was denied. There were some dissents from that denial. You had Judge Van Dyke, who was joined by 5 other judges in the Ninth Circuit. The dissenting opinion stated that the private property default rule in Hawaii effectively nullifies the Second Amendment rights of Hawaiians and has no grounding in the historical record. Now, this horrible law in the Ninth Circuit review here is currently making its way to the Supreme Court. It's in the Supreme Court. Hawaii is asking for Supreme Court review on this emergency basis, and they want the reversal of what the Ninth Circuit said. Now, this case theoretically had a long shot of getting Supreme Court review because it's still in an interlocutory posture. It deals with the granting of a preliminary injunction, not a final merits ruling. However, now with the Trump administration, the AG's office, the DOJ stepping in, filing an amicus brief in support of this lawsuit, it is more likely that the Supreme Court will grant review to this case. This is huge because the federal government is now pushing for the Supreme Court to review and strike down these state carry bans. And even better, now you have the Trump administration being joined by 25 states who are also calling for Supreme Court review of this issue. In the recent amicus brief filed by the United States government, they state that the near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary, law-abiding citizen has a general right to public carry arms for self-defense, just as states may not limit that right to those who show a special need for self-defense. States may not limit the right to those who aimlessly wander the streets. Now, one of the interesting things with this brief is that the federal government says that the Supreme Court should not be afraid to take this case on review, even though it's in an interlocutory preliminary injunction stage. This is important because we have seen the Supreme Court step in on other legal issues when they're dealing with preliminary injunctions, but when it came to the Second Amendment, in that context, the Supreme Court has generally just avoided these issues categorically. The federal government here argues that the Supreme Court should give opportunities to these two-way cases like they do with other legal issues. The government also snuck in a mention that it's also time for the Supreme Court to finally review rifle and magazine bans and finally answer the question of whether those type of arm bans are also permissible. Now, these arguments are echoed in the brief that was filed by the 25 states in support of the Supreme Court granting this emergency review. In the brief of the 25 states, they argue that Bruin reassured law-abiding gun owners that the Second Amendment was no longer a second-class right. But lower courts have largely failed to follow through on that promise, resorting to manipulative en banc practices, ahistorical interpretations of covered arms, and improperly calibrating the level of generality for Bruin's inquiry. These incursions on citizens' public carry rights will continue to grow unless the court intervenes. They also go on to state that each of these ploys chips away at the scope of the citizens' Second Amendment rights, and if unchecked by this court, Bruin's reassurance will be little more than an empty promise. Now, those are some strong statements being made to the Supreme Court where you have these states telling them expressly that you wrote Bruin and said that the Second Amendment is not a second-class right. However, since Bruin, lower courts in states like California, Hawaii, New York, and others have openly refused to follow that ruling. The states tell the Supreme Court that if you do not take this case and potentially others like it to correct all this lower court defiance and the bending and twisting of the Bruin rationale, really Bruin becomes an empty promise with no teeth. With this DOJ brief and the 25 state brief that also is in support of this case, I think there is a stronger chance now that the Supreme Court could grant review to this case, even though it's in an interlocutory posture, even though it deals with a preliminary injunction. It seems maybe more likely the Supreme Court would grant review. The conservatives on the Supreme Court now have a stronger signal from the administration and also now a majority of the states that they do support striking down these concealed carry bans and that they are in favor of the Supreme Court stepping in on an emergency basis. Ultimately, you still need the Supreme Court votes to take this case. You need at least 4 votes, but really you need more than that because they're not going to grant review to a case unless you have enough votes to rule the way that you want. So you need those 5 votes, 6 votes to rule the way that you want. So really that's the big question going forward. Are there going to be enough justices on the Supreme Court who look at this issue, look at the lower court defiance, and say, yes, we need to finally address this? But overall, it's great news coming out of the Trump administration that they are supporting this concealed carry case on an emergency basis in front of the Supreme Court. And it's great to see so many states also jump on board in support of this Hawaii case that is now pending in front of the Supreme Court. So we're going to see how this plays out, how this develops, and hopefully the Supreme Court takes this issue serious because, like the states warned against, if the Supreme Court does not take action, it just sends a clear signal to everyone, the lower courts, the states, that they can continue to do this and the Supreme Court will do absolutely nothing. So again, we'll see how this plays out. As we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.